The meeting of the Subcommittee of Courts of Justice Criminal Law Subcommittee will come to order as we start the agenda, and I will say this distinctly, and we'll make sure that we do it one more time because I'm doing it as much for staff as I am for the public and any patrons. We have a number of bills that will go by that have been on our docket. As I have talked with the various patrons, they're really doing their good work to get these bills into the best shape possible as we take them up. So this has all been very productive time being spent. With that, as I go down the list, the first one is HB 635. This is my prerogative, moving it to a later agenda where we're taking up issues that deal with juveniles that are in the justice system. 635 will go by. 697, at the request of Patron Maldonado, will go by. HB 1242, Willett, will go by. HB 78, Watts, by. HB 267 will go by. And Converse Fowler's HB 1359 on the same subject as HB 78 will also be taken up in conjunction with that bill. And finally, I have one other request, and that is that HB 860, the patron has asked that it be stricken. Is there a motion?
So moved.
It has been moved and seconded that HB 860, that we strike it. This is a voice vote, I believe, or no, it's a recorded vote. Please open the roll. Thank you. Members, cast your vote. The HB 860 has been stricken unanimously by a vote of 8-0. Thank you, Delegate Williams.
Speeding us along.
And now I will take up bills in order. Again, I want to make sure that we are all aware that because of everyone's time pressure at this point in this session, we will be adjourning at 4 o'clock. So we'll get as many bills as we can. But I want to start with any patron who has members of the public here to speak. And that would be HB 161, first on our docket, Delegate Siebold. Bold.
Good afternoon, Madam Chair, members of the committee. First, Madam Chair, I have a substitute.
Yes, Madam Chair, members of the subcommittee, there's a substitute that's been posted online and it's being distributed to you now. What the substitute does is adds 2 drug crimes that are specific to prisoners. Updates catch line, and throughout the bill it references administrative procedures and penalties. With some of the restructuring, it removed the subsection C2 that was in the bill. So as a restructuring matter, anything that was originally C1 is now just in subsection C. And I'll let the patron explain more of these changes.
Move the substitute.
Second. It's been moved and seconded that we adopt the substitute for House Bill 161. All those in favor say aye.
Aye.
Opposed?
Great. Thank you, Madam Chair. Madam Chair, members of the subcommittee, every 11 minutes in the United States, someone dies of a drug overdose. And it doesn't have to be this way. We have Narcan and other solutions to treat overdoses, and if caught in time, it doesn't even have to be fatal. But someone experiencing an overdose needs help. They can't always report it themselves. That's why we should do everything we can to encourage people to help someone in the midst of an overdose and not punish them for doing so. Luckily, for those who are not incarcerated, they have immunity from arrest if they or someone they know is experiencing an overdose. Unfortunately, under current Virginia law, this is not the case for those who are incarcerated. If you're experiencing an overdose in prison or jail and it's reported to staff, you can be re-prosecuted for an additional crime, which could lead to another additional 4 years, depending on some circumstances. In addition to being rearrested, you could face strict internal disciplinary action, solitary confinement, loss of recreation, visitation, telephone privileges removed. These are amongst the penalties. This bill will simply extend those reporting protections to people incarcerated in Virginia and eliminate the barriers to reporting an overdose. Madam Chair, drugs have infiltrated our prisons and jails, mostly coming in through staff. Last summer, we saw a rash of incarcerated overdose deaths, including 3 deaths alone over just 2 days at Greensville Correctional Center. As a Virginia sheriff shared with me, I believe in this bill because I would rather save a life and know about somebody overdosing. If they don't tell us there's fentanyl in a cell, it's already in the cell and it got past us. If an inmate cellmate overdoses, we shouldn't discourage him or her from reporting it for fear of prosecution. Virginia prisons and jails need an urgent intervention to stop these overdoses, and they need it right now. I hope you consider this bill. Thank you.
Thank you, Delegate Siebold. Are there questions of the patron? And again, use your request to speak button, please. I see first Delegate Hernandez.
Thank you, Madam Chair. More of a question for council, really, just if they could explain once more how this is slightly narrower than the original version, since we're just seeing the printed out version of the substitute. I just want to make sure we're fully understanding the changes.
Madam Chair, Delegate Hernandez, is actually, I wouldn't call it narrower. I think it's probably a little bit more expansive to protect. So the changes in this from the original bill are that there are 2 code sections, which are 53.1, 203.5, and 203.6, that deal with penalties for prisoners who possess chemical compounds, controlled substances, marijuana, or Suboxone. Those were not in the original bill, and since those are criminal charges that prisoners themselves could face, those were added in the subsection, the later subsection where the evidence was taken out. That was done so that evidence of who is dealing the drugs could still be maintained by the Department of Corrections or the jail, but it's not, can't be used again to prosecute the overdose E, I guess is the best way to put it.
Is there a follow-up? Delegate Williams.
Thank you, Madam Chair. Question for the patron.
Please proceed.
Delegate Siebold, I'm supportive of this bill, but I want to make sure that there's no ability to misuse it, right? So possibly inducing an overdose. I know that sounds crazy, but you know, in some of these situations, they've got sort of pod folks who are looking out for everybody, and that's one of the issues is they don't report because they don't want anybody to know. And so I am a little bit worried about the bad actors, and it's an open question to others in this room too, is are there implications that we need to watch for that says if this person overdoses, then I can't get in trouble, so I'm going to do something bad? Does that make sense?
Yes. We actually have DOC, Madam Chair, we actually have DOC in the room, and I'm sure that that's something that they could explain a bit better than I can.
It would be appropriate for Department of Corrections to come forward to answer the question.
Good afternoon, Madam Chair, committee members. My name is Marcus Elam, Operations Administrator for the Department of Corrections. And to the question that was posed, that's one of the concerns that we had that we worked out with Delegate Siebold to make sure that the evidence, particularly that is found that in relation to the person who's overdosed, we would still be able to use that to investigate and address those folks who are dealing drugs. So that's one of the changes that we felt as a department was a positive change that would allow us to continue to do that for that purpose.
Thank you.
Thank you. Are there other questions of the patron? If not, anyone who wishes to speak in favor of the bill, if you would all come up at the same time so that we know how the line is forming. And again, please be expressive but brief.
Good afternoon, Chair and committee. I'll just say I support because I know it's a long line behind me, but as someone who does reentry services and work with individuals who are incarcerated, there is no harm in having Narcan at all. And a lot of people are not sentenced to die, so we support the bill. Thank you.
Thank you.
Good
Good afternoon, Madam Chair, members of the committee. Sean Winneto speaking on behalf of the ACLU of Virginia, and we do support the bill. Thank you.
Good afternoon, Madam Chair, members of the committee. Chuck Mayer representing Julian Legal, a civil and human rights firm, and we support the bill. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. I am Sincere Allah, former peer recovery, peer support specialist inside the Department of Corrections. I support this bill.
Thank you.
Madam Chair, members of the committee, as mentioned previously, that's one example why the department does not oppose this bill. The other reason I want to thank Delegate Sebo for working with us for these particular changes, because it does allow us to, one, continue to address the addiction issues that our folks have, as well as work hard to try to keep those folks who are trying to bring the drugs into the prison and distribute them, allows us to continue to address that issue as well. So for those reasons, we don't oppose the bill.
Thank you.
Michael Sizemore, Advocacy Manager at Sarah. We support the bill.
Thank you. Is there anyone in the audience wishing to speak in opposition to the bill? Please come to the microphone. Seeing no one, I don't have my list. Is anyone online wishing to speak to the bill? Are there any further questions from the panel? Delegate Siebold, you have the last word.
I'm good. I know you have a busy docket, so thank you, Madam Chair.
Okay. A motion is in order.
Madam Chair, I'd like to move to report.
Second.
It has been moved and seconded that HB 160, as a substitute.
Sorry.
And and a letter, I'm sorry, the letter says to appropriation. So the proper motion is a motion to move to report the substitute and refer it to appropriations. Please open the roll. All those members cast your vote. Please close the roll. HB 161 reports and is referred with substitute to appropriations by a vote of 6-1. Thank you very much, Delegate.
Thank you. Thank you, Madam Chair and members of the committee.
Okay. Next on the agenda, I know Delegate Price also has speakers from the public. This is HB 612. Delegate Price?
Yes, Madam Chair, members of the committee, current code allows for unpaid court debt for criminal defendants to be sent to collection 90 days after a final judgment if the defendant is not on an established payment plan. When these accounts are sent to collections, they incur a 17% collections cost, increasing the amount of fees owed. For those reentering society after incarceration, 90 days is a brief amount of time for them to pay the court debt after being released, as individuals trying to get jobs, housing, healthcare, and other costs, all which will help them re-enter and reduce chances for recidivism. More time can help them get established in order to pay back the fees. This will actually save the Commonwealth and defendant money. House Bill 612 would adjust the 90 days to 180 days, which would allow for more time, but also align the collections timeline with that we switched for the interest when that starts to accrue. And this bill requires clerks to enter a due date on costs based on the maximum active period of incarceration of all charges in one sentencing event. The bill does not remove the obligation to pay, but changes the time that they will have to pay before collections and gives them clear information on a due date. I would like to thank Legal Aid Justice Center and OES who helped us work on the language over the last couple of years. And with that, I do have a few amendments based on further feedback from OES in making the process workable.
Okay, staff, can you please report the amendments?
Yes, Madam Chair, members of the subcommittee, these are line amendments. If you look at lines 156 and 157 at the very end of the bill, the new subsection F, this is where they're going to go. At the beginning of line 156, it strikes that and inserts for which. And then on line 156, after that such defendant, striking is convicted of and inserting was sentenced on the same day. And on line 157, after agreement, it inserts the code section referencing deferred payment agreement. So I'm going to distribute this line amendments now, and then I can read the sentence back if so needed.
Thank you, Counsel. I assume that can be taken as a block? Yes. Voted on as a block. Motion's in order?
Move the amendments.
It's been moved and seconded that we adopt the amendments as reported. All those in favor, as you see them before you, please say aye.
Aye.
Opposed? The bill is amended.
And Madam Chair, the amendments again were from OES and just trying to make it very clear that it's one sentencing event and if someone should have additional charges, what the process will be, that we really mean this for that one sentencing event for the 180 days for that.
Thank you. Are there any questions of the patron on the bill as amended? Seeing no one requesting to speak, anyone speaking in favor of House Bill 612, please come to the microphone.
Hi, Madam Chair, members of the committee. We want to really thank Delegate Price for all her hard work on this bill, and we support this bill. Also, the Commonwealth Institute, who is upstairs right now in Senate courts, also supports this bill. Thank you.
Thank you.
Good afternoon again. I did not introduce myself. Sheba Williams.
Yes,
from No
thank
Left
you
Turns.
I appreciate that.
As a direct service organization who works with individuals who are coming home, that first 60 days is the hardest, so we absolutely support this bill, and thank you.
Thank you.
Hello, Madam Chair, members of the committee. Dominic Martin, New Virginia Majority, and we support the bill and thank the delegate for her continued work on this issue.
Thank you. Is there anyone in the audience wishing to speak against the bill? I see we have someone online. Please proceed, Mr. Fatai. And
Madam
please
Chair,
pronounce your name
thank
properly.
you very much for hearing from me. I'm Rami Fadahi. I'm the Commonwealth's attorney for the city of Norfolk, speaking in support of the bill. I'll be brief. I'm here on behalf of Virginia Progressive Prosecutors for Justice. The 8 prosecutors in our organization all support this bill. We are the prosecutors from Norfolk, Albemarle, Arlington, Charlottesville, Fairfax, Fredericksburg, Portsmouth, Prince William. This is a public safety bill as much as it is a court cost bill. Anything that we can do to make sure that people meet their obligations, but also are able to get back on their feet after they're released will reduce recidivism and make all of our citizens safer. Thank you to Delegate Price for carrying the bill. Trying to keep you on track on time. Much appreciated.
Thank you. And again, the print is very fine on my screen, Mr. Fatai. I hope I've said it properly this time. Are there any other questions on the bill? Comments? Questions? You have the final word, Delegate Price.
I hope you will support it.
All right. A motion is in order.
Move to report.
Second. As amended.
Move to report as amended.
It has been moved and seconded that HB 612 be reported as amended. Please open the roll. Members, cast your vote. HB 612 reports with amendments by a vote of 4-3.
Thank you, Madam Chair and members.
Okay, next. Is there any other patron here who has members of the public who are here to testify? Seeing none, then the next bill on our docket would be HB 822. Delegate Cherry.
Madam Chair, thank you so much for the opportunity to come. I'll direct your attention to House Bill 822, and there is there's a amendment in this form of a substitute.
If you could distribute. Do we have an amendment in nature substitute?
Yes, Madam Chair, members of the subcommittee. This new amendment in nature of substitute changes the form of the bill. This is now a Section 1 work group bill directing the Secretary of Health and Human Resources to convene a work group to study transfer of custody for patients under an emergency custody order or temporary detention order. I will let the patron explain more about the participants and what they should study.
I assume everyone has it. Are there, it is in order to motion on the substitute?
Move the substitute.
Is there a second? Are there any discussion of the substitute? I want to be sure what I'm looking at here.
Absolutely. I'm happy to explain it, Madam Chair, if you're ready.
I appreciate, Delegate Cherry, that as I read the bill, I was not comfortable with proper custody of the people who are in crisis.
Madam Chair, I was able to do something little seen here in Richmond, and that was to bring all factions of every side in unison against a bill, including the patron. And so as we worked through this process of what we needed to accomplish, we realized that 822 in its original form did not do that, but we now have come to an agreement that we need to talk about how to fix this. And so what this is a Section 1 bill that brings all the relevant players from the justice side, the law enforcement side, the hospital side, the transfer side, all to the table to say, the system we have isn't working, how do we fix it? And so that's all the bill does, is it brings all the relevant players to the table, holds our feet to the fire to make sure we're having those discussions to get law enforcement out of the mental health system in terms of making sure that they're not sitting at hospitals for days and weeks on end, and we're not arresting people that are in a mental health crisis, which is what we're doing now.
Thank you, Delegate Cherry. With that, all those in favor of the motion, unless there's further comments or questions, please say aye.
Aye.
Opposed? So this is the motion was on the substitute.
Correct.
Now, before we take discussion then on the bill before us, I am going to rule that I'm 99% sure that this is going to have to be re-referred to rules as a study.
Correct.
So,
as the delegate noted today on the floor, yes, ma'am.
Thank you. Are there questions of the patron? Is there anyone in the audience who would like to speak on the bill? Speak for or against?
Madam Chair, members of the subcommittee, we, Elizabeth Hobbs with the Virginia Sheriff's Association, we support the bill. We'd like to extend our thanks to the patron for bringing it and for being protective of law enforcement and the job we have to do. Thank you.
Is there any, please come forward. Office of the Executive Secretary, Supreme Court.
Eileen Longenecker with OES at the Supreme Court. I was just looking at it quickly. I think instead of the Virginia Magistrates Association, it might be more appropriate to say OES, since magistrates are under the judicial branch, and that might be a more appropriate to have us in there as opposed to the Magistrates Association.
I would consider that a friendly
It has been moved. Has been motion?
I'll make a motion to adopt that line amendment.
It's been moved and seconded to make that line amendment. I'm assuming that we are substituting the Magistrates Association for the Office of the Executive Secretary.
Yes, and certainly if we believe we need to have magistrates with us also there, I mean, we can do that.
Okay, thank you. With that explanation, all those in favor of the amendment to the substitute, please say aye.
Aye.
Opposed? Okay. Is there anyone else in the audience who wishes to comment? I see we have online again, Mr. Fatah. I'm getting closer.
Madam Chair, I answered just about anything. Appreciate you recognizing me. Again, in the interest of knowing you all have to have a stop at 4 o'clock, I want to express the appreciation of VPPFJ to Delegate Cherry. Every one of us, I think, across Virginia is seeing a real shortage of police officers, and this is both a public safety bill and that it allows, even as a study, would allow for potentially freeing up law enforcement resources for law enforcement court functions, and it would allow people in mental crisis to be dealt with by non-law enforcement officers. So we support. Thank you.
Thank you. Seeing no one else requesting to speak, a motion is in order. Oh, you have the final word. I'm sorry.
I think it's headed in a good direction. I don't want to mess it up.
Motion is in order.
Move to report and refer to rules with amendments.
It has been moved and seconded that HB 822, as substitute, be referred to, be reported and referred with substitute to rules. And I will try to make sure that this is expedited, even if we don't have a full meeting on Friday to affirm this. With that, please open the roll. Members, cast your vote. Please close the roll. HB 822 reports and is referred with substitute to rules by a vote of 7-0 unanimously. Thank you very much.
Thank you, ma'am.
Delegate Cherry. You have another.
823, yes, ma'am.
Please proceed.
Move the amendment.
Madam Chair, members of the subcommittee, there's an amendment in my hand. I'll pass it out to you as soon as I can. What this would do on line 41 is, on line 39, it would add subdivision A, and then on line 41, a subdivision B that states the law enforcement agency elects to provide transportation. It just splits that sentence up into an A and a B part, so you can see it.
Okay. Are there any, there's a motion before us?
I'll move the amendment.
It has been moved, and any questions? It's been moved and seconded that the block amendments as reported be adopted. All those in favor say aye.
Aye.
Opposed? Proceed to explain as amended.
Awesome. Thank you, Madam Chair. What this bill does is also dealing in the TDO, EDO, ECO space. And what it simply does is, in the code as we currently have, sheriff's office and police departments can use alternate transportation to transport someone from a facility to where they're going to receive their long-term care for their mental health. And what this does is simply define what readily available means for that alternate transportation. And so it adds a 6-hour time. Some localities you'll go to and they'll say alternate transportation is ready in 12 hours or 15 hours or 18 hours. And we think it needs to be specified that 6 hours is what we mean by readily available if you're going to use an alternate transportation. The amendment simply gives the sheriffs who had some concern with that legislation that they weren't going to be able to move someone in the less than 6 hours, that they still have that authority to move. If they have the ability to transport under the 6-hour time limit, they still have that flexibility to do so.
Thank you very much for that explanation. I will say that I appreciate, because as I read the bill, I didn't see that your object is to say maximum of 6 hours. And that was not readily apparent to me, and that is what is before us. Are there questions? Seeing no member request to speak, is there anyone in the audience that would like to speak to the bill for or against? We'll start with anyone just speaking to the bill or for it. We'll start with for it, I assume.
Elizabeth Holmes, Virginia Sheriff's Association. We support the bill. We're grateful for the amendment with the patron to allow us the flexibility to veto, if you will, if the sheriff can make it in less than 6 hours.
Thank you. Speaking for the bill.
Hi, Josie Mace, Department of Behavioral Health and Developmental Services. We want to express our support for this bill and thank the patron for bringing it. We also have someone here available to answer technical questions if you all have any.
Thank you. Is there anyone in the audience wishing to speak against the bill?
I don't think so.
Seeing no one, we have online Mr. Fati. Totally messed it up this time.
I answered anything, Madam Chair. The VPPFJ supports for the reasons we supported the prior bill. Thank you. Thank you, Delegate Chair.
Okay, thank you. Are there other questions? Final word?
Pretty simple bill, just adds a time limit, so thanks.
Motion is in order.
Move to report.
Second. It has been moved and seconded that HB 823 be reported. Please open the roll. I'm sorry, I didn't see the with amendments. Absolutely,
move
thank
to
you.
report with amendments.
Please open the roll, cast your vote. Please close the roll. HB 823 reports with amendments by a vote of 7-0 unanimously. Thank you,
Madam Chair,
much.
members of the committee.
Okay, now next on the docket is Delegate Kent with HB 898.
Thank you, Madam Chair, members of the committee. I appreciate your consideration of House Bill 898. I'd like to describe what this bill does, which is largely technical regarding the Department of Forensic Science. This bill makes several amendments to the existing statutes affecting the Department of Forensic Science by updating certain terms and practices due to scientific advancements and the fact that we're in 2024 today. It will reduce wasted criminal justice system resources by requiring that a person seek a court order for DFS to conduct specific scientific testing, that they first must verify that the lab has the methodology to complete that test prior to filing a court motion for such testing. It also creates efficiency in evidence for submission by authorizing documentation of the chain of custody between law enforcement and DFS by electronic means other than only depending on the current paper forms that are currently utilized. It also protects genetic privacy of the accused, victims of crimes, and others by the requirement that genetic profiles, which is the word that you'll see struck in the code, be provided, which is possibly obtained by members of the public, while at the same time continuing to provide the defense and the prosecution access to all relevant information and underlying data in the DFS data system and case file. It eliminates impediments for DFS to provide timely communication with other laboratories during criminal investigations that are concerning DFS that has DNA information on file for a specific individual. Basically, it makes the Virginia statute consistent with federal law and the National Data Bank for DNA. I'd like to specifically go back to the section regarding the change of code of 19.2-270.5 and 19.2-310.4, which addresses the word profile from certain requirements, just to elaborate on that specifically, since that's a little bit more than technical. DFS has issues which are known as certificates of analysis that report the results of scientific analysis of case files, and they're concerning the results of DNA testing. DFS includes certain genetic information known as the allele tables in these certificates. If the matter goes to trial, the certificate of analysis is part of the court case file and is subject to review by the public. Private genetic information of the accused, victims, third parties, anyone in the file is included in these allele tables. So due to scientific advancements, allele tables may no longer be representative of the data that's available for interpretation as we're using other forms, which is included in the DFS case file. If the requirements concerning the profiles were removed, the defense and prosecution still have access to all of the data contained in the DFS case file through the existing means, but the public would not have access to that DNA information. So overall, this bill keeps the law consistent with current scientific and technical advances while also protecting any privacy concerns of those that may be accused or victims or parties of such. It will create efficiencies and overall remove impediments that would help the timely provision of government services, enhancing public safety while also reducing administrative cost. So thank you for your consideration. I tried to do that somewhat expeditiously.
And this is a serious bill, and I thank you for articulating this overview. I have a basic question as I looked at the bill, and this would be of counsel, Mr. Mutnick. As I looked at the importance, and which is why this bill is before us, of making sure that this data is not improperly used, and we're all concerned about what can be done with algorithms as you pull bits and pieces of data, and this then becomes something that is misused in the public. My question is, what is the penalty for those who aren't granted official access through this bill if they in any way allow their access to that confidential data to be breached by anyone, and what might be the penalty for breaching? But particularly I'm concerned about the penalty for someone who doesn't respect the custody of this information.
Madam Chair, so 19.2.310.6 lays out the penalties for unauthorized use of the DNA data bank. It is a class 3 misdemeanor for anybody who, without authority, disseminates the information. It is a class 1 misdemeanor if somebody disseminates it knowing that it will be used for a purpose other than authorized by law. That is a statute that is really focused on the people who receive the information through their employment at DFS. I would suggest an amendment to this bill that would include language in that code section that would also reference those who receive the information pursuant to these code sections, which would be 1910-270 or 19.270.5, 310.4, and 310.5. And I have drafted language to that effect, if it's the will of the committee.
Would you so present that,
yes,
that amendment?
Now 19.2.310.6 is not currently in the bill as a statute, but it is relevant to the bill. And
so it
I would
requires
add
a substitute.
Yeah, it would be a substitute, and I would add the language, a new paragraph in that statute that says, any person who receives information pursuant to 19.2.270.5, 19.2.310.4, or 19.2.310.5 shall not disclose such information to any third party who is not an agent or employee of the parties or an expert witness unless disclosed pursuant to a valid court order. Any person who violates this section is guilty of a Class 1 misdemeanor.
Thank you. Before I ask for a vote on this, clarification. Is the offense carry each breach? Let's say that there are multiple pieces of information that get out within within one case, and they are received by more than one party. Are they multiple offenses, and does that need to be spelled out if that's the case?
I would say the language as written would, I would say, would apply to each time because the crime itself is the dissemination. So it's each time it's disseminated. If you disseminate once a lot of data, that's one charge. If you multiple times or disseminate it multiple times to one person or disseminate it multiple times to many different people, that would be different charges. We can delineate that. This language is actually taken in part from 19.2.187.2, which deals with dissemination of the material for those who receive it pursuant to a subpoena ducis tecum. And so this is existing language in the law, but modified slightly just to apply to these code sections.
So just to make sure I'm understanding you, so what we are about to vote on as you reported it would be, doesn't matter if it's the same case, if there's multiple breaches, each one is an individual offense.
So long as, yes, unless it is done in one, if I took a stack of papers and gave it to Mr. Hatcher, that's one offense. If I took each individual paper and gave it to Mr. Hatcher on different occasions, that would be multiple offenses.
On different occasions. Thank you, dear. A motion would be in order.
Madam Chair, I move the substitute as presented by council.
Second.
Are there questions on the substitute? All those in favor of the language which will be incorporated into a substitute of the bill, please say aye.
Aye.
Those opposed? And Council, you have another amendment.
Yes, Madam Chair. I'm working with DFS in 19.2.270.5. They're removing the copies, as Delegate Kent said, the copies of the allele tables or the profiles that are distributed to Defense Counsel. That is something that Defense Counsel can also get through 19.2.187.2, and to avoid any confusion of the General Assembly acted, so this must do something different. I would suggest in 19.2.270.5 adding the following language, which is nothing in this section shall be construed to limit the ability of the parties to obtain additional writings or documents, including the profiles used to reach the conclusion of the report pursuant to 19.2.187.2.
Is there any questions of Council on this remanded? A motion is in order.
Madam Chair, I move the amendments as presented by council.
It has been moved and seconded that the amendment as reported be added to the substitute bill. All those in favor say aye.
Aye.
Opposed? And again, I do want to finish action on this bill. We will not be taking up any more bills at this meeting, as we will adjourn when this is completed. Are there anyone wishing to speak on HB 898?
Madam Chair, Director Jackson is here with DFS if there are any technical questions or anything that they can help provide as well.
I assumed that this was an administration bill, so I think that the director would approve of it, right? An agency bill, excuse me, an agency bill, please.
Real quick.
Yes, ma'am. Madam Chair, members of the subcommittee, my name is Linda Jackson. I'm the director of the Department of Forensic Science, and I very much appreciate Delegate Kent carrying this bill for us that does make a number of technical changes that are appropriate.
Thank you. Any questions of the director? If not, a final word? No?
We appreciate your support of the bill.
A motion is in order.
Move to.
Second.
It has been moved and seconded that HB 898 be reported as amended through a substitute that incorporates all of the amendments that we have adopted. Any questions? Please open the roll. Members, cast your vote. Okay. I close the roll. HB 898 is reported with substitute by a vote of 7-0. Thank you very much.
Madam Chair and committee, thank you.
And with deep apologies to, again, Delegate Oates, I understand belatedly that you did have people in the audience to testify, but I'm sorry that we really need to adjourn at this time, and we will docket it at when it is best for your presentation as a little consolation prize. With that, the meeting is adjourned.